1:11:34 a.m. 1:11:34 a.m. 7,000 pounds, 25 miles an hour. 1:11:34 a.m. 7,000 pounds, 25 miles an hour. That's what this case is about. On May 7th of 2023, at 1:11:34 a.m., the defendant, William Bud Ackerman, drove his 2019 Ford F-250, 7,000 pound 2019 Ford F-250 at 25 miles an hour into the body of Davis McClendon. BAM! And that's what happened. He intentionally drove his car into the body of Davis McClendon. And that's what this case is about. And I submit to you, ladies and gentlemen, the evidence you're going to hear, you're going to see it, you're going to hear it, and you're going to feel it as we present to you that at 1:11:34 on May 7th of 2023, the defendant intentionally drove his truck into Davis McClendon and murdered him. Good morning.
Good morning.
My name's John Metters. I'm honored to be here with Mr. John Conrad. We work for a South Carolina Attorney General, Alan Wilson, in the Attorney General's office. Since we have the burden of proof, we have some folks helping us here. Thank goodness, we need it. Daniel Clone, Matt Ellis, and Danielle's even got our mother Vicki here today. But we are here today representing the people of the state of South Carolina, the people of Greenwood, against the defendant, William Bud Ackerman, who's represented by Mr. Jack Swirling, a distinguished member of the South Carolina Bar. As His Honor just told you, we all have roles in this case. We all have roles. Mr. Swirling has his role. We have our role. We're advocates. His Honor is the judge of the law. He is the law. He decides what law we all abide by and what law you jurors will decide this case on. But most respectfully to His Honor, to all the parties involved, your role is the most important of anyone here. You're the judge of the facts. You decide what's credible, what's believable, and you'll use that determination, deciding what the truth is, as you apply the facts as you so find them to the law that the judge is going to give you, and you'll come up with a verdict. I've heard a judge describe it years ago. It's like a game. It's basketball game is the furthest thing from the game. I can assure you there's nothing more important than this. When we have our roles, this is kind of my office. We do this week in and week out. We all love it. But it's almost like a basketball game, and we're here every week, week in and week out, the referee, the other players, but a star player comes in and week out, and that's y'all, the MVP, who determines what the outcome of the game is. But it's no game. This is the most important case that will be tried in this state, in this country, this week. It's important to the defendant. It's important to Davis McClendon and his family sitting here. This is both of them's day in court. It doesn't get more important than this case to both parties. This case will be over this week probably, but the shortness of the case does not take away from the importance to everybody in this case. His Honor just said, thank you for being here. I want to thank y'all for being here. We both chose y'all. Both of us chose y'all because we knew and we know that you will all be fair and impartial. No enemies to reward, no friends to reward, enemies to punish. You're here to decide this case based on the evidence you hear that comes through the witness stand. You decide what's credible, believable, and His Honor said, use your common sense. And we submit to you, that's what will help you decide this case. Just good old common sense. It's not complicated, but it's important. Ladies and gentlemen, what's he charged with? Defendant is charged with the crime of murder. Everybody knows what murder is. We see it so much on TV today. And murder is the malicious, intentional killing of another living, breathing human being with malice aforethought. What's malice? State must prove malice. Malice is an evilness, a wickedness, a spitefulness one person chose to another. It can be expressed, I'm going to kill you. Or it can be inferred under circumstances from one's conduct. Inferred by not braking. Inferred by aiming your truck right at somebody as they're standing waiting to talk to you. Express malice, inferred malice. We submit you're going to hear some express malice. But that'll be up to you to decide. Aforethought, malice aforethought is a term of art. We don't have premeditation in the state of South Carolina. You don't have to plan, decide in advance, I'm going to go kill somebody. Law doesn't require that here in this state. Premeditation is not required. Malice only has to exist at the time the fatal blow is inflicted. Malice aforethought, at that time when the gas is on the truck, at that time when it's not on the brake, at that time when the truck runs into Davis's body. Malice aforethought. That'll be up to you. There are different types of evidence, ladies and gentlemen. There's direct evidence, evidence that you gather with one of your senses. You directly gather it. You hear it, you feel it, you smell it, you touch it. You come in here and tell your jurors, witnesses tell you, this is what I heard, what I felt, what I smelled, what I touched. There's circumstantial evidence, which is evidence of a fact or facts which leads to a fact in question. I often give the example, I usually have ink spots on my shirt where I put my pen in and forget to close it. You wouldn't have seen that, but if you know I have an ink spot in here that I had a pen in there, that's circumstantial evidence. In this case, you're going to see circumstantial evidence of the defendant's truck. After he hit Davis, something happened to his truck and he left an oil spill all the way from the location of the killing back to his folks' house where he was living. All the way back, an oil stain. You didn't see it, but they followed it back. That's circumstantial evidence that he drove his truck from the crime scene back to his parents' house. You're going to hear evidence, videos, some audios, pictures, all types of evidence. The only evidence you can consider in reaching your verdict is the evidence that comes out of this witness stand, and the evidence His Honor allows relevant evidence to come before you. That's what you're going to be able to consider. What's our burden? The burden, as His Honor said, on the state in this case is the same that's on every prosecution in this country. It's beyond a reasonable doubt. Beyond a doubt that'll make reasonable folks hesitate to act. That's our burden. We have to prove that to you. It's not beyond all doubt. If you had that burden, you wouldn't need this courthouse. Beyond all doubt would be your own video. I tape all the time, all your actions. Nobody wants that. And the law doesn't require that. It's beyond a reasonable doubt, beyond a doubt that makes reasonable folks hesitate to act. And that'll be up to y'all. And that's the beauty of this system. Folks from the community come in, promise to be fair and impartial, promise to be, listen to the evidence, and make a decision on what they believe is right. And has the state met their burden of proving the defendant guilty beyond a reasonable doubt? We respectfully submit and hope you'll find at the end we have met our burden. I think we'll go beyond that, but we only have to go beyond a reasonable doubt. But that's our burden. We have to prove the defendant intentionally killed Davis McClendon. And folks, that's really what it boils down to. Sometimes I lose sight of the forest for the trees. My wife tells me that all the time. She says, keep it simple. So I'm going to keep it simple. If we prove to you beyond a reasonable doubt that he intentionally drove his truck into Davis McClendon, he's guilty of murder. It's that simple. We respectfully submit. It's that simple. So how are we going to do that? What happened? Evidence will show that the defendant, William Bud Ackerman, was married to a young lady named Meredith. Went by Meredith. Ackerman's now Meredith Haney. They were married, had children. A year before this incident, spring, May of 2022, they separated. It happens. It just didn't work out anymore. They split up, began divorce proceedings. It wasn't going to work out. Still wanted to do what was best for the kids, but that relationship had ended. Summer goes into the fall of 2022. In this December of 2022, Meredith begins a relationship with Davis McClendon. And the evidence will show it had nothing to do with the breakup of the defendant and this young lady. Nothing. It was over. It was over. Well, except one person couldn't accept that it was over. And as we go into fall of 2023, since the winter of 23 into the spring, a few weeks prior to this incident, the defendant finds out they are dating, they're having a relationship, and we submit to you the evidence will show he can't stand it. He doesn't want it to be over. He's not going to let it be over. And as we move up to May 6th, May 5th, he finds out a few weeks before this relationship's going on, doesn't understand it, it's not right, he doesn't want it to happen. We go to May 6th, and this is what I want y'all to focus on, what the evidence will focus on May 6th. Davis McClendon is out with Meredith. They're going to a place called Break at the Lake. There are several places here, y'all know them much better than I do. There's Break on the Lake restaurant out at the lake. Y'all shaking your heads, y'all know where that is. They were out there eating. There's a place called Key West Bar. Some of y'all may know where that is, may not. It'll show that the defendant was there after the victim, Davis McClendon, and Meredith leave Break on the Lake. And you're going to hear that Meredith was getting texts, phone calls from the defendant at this time. Where are you? What's going on? The defendant leaves Key West, starts going out to Break in the Lake. At that point, you'll hear that the decedent, Davis McClendon and Meredith, go to this Key West bar. You're going to see videos from these places. You're going to see videos. We're going to give you a timeline. And then once the victim, Davis and Meredith, are at Key West, you're still going to see phone calls coming in from the defendant. We believe we'll be able to argue he's looking for both of them. Doesn't want this to be going on. Angry it was going on. Going to stop it. And finally, through phone calls and texts, the defendant says, I want to talk with Davis. And you're going to see Davis leave the bar and go to meet him. But prior to that, we're going to show you evidence. And remember intent, ladies and gentlemen. We're going to show you intent. We can't open up somebody's head and look at their brain and see what they're thinking. But we've got to prove intent to you. This whole case is intent. We've got to prove it to you. One way we're going to prove it to you in this case is through that 2019 Ford F-250. There's something in there called the infotainment system inside the car. And there's a software called Burla. Mr. John Conrad's going to explain that through witnesses. That they take it out of the Ford F-250 and you can show where a person went, what time they went there, the speed they went there, when they were braking, when they were turning. And we believe we're going to be able to show you that the defendant left Key West Bar and went looking by Meredith's house, then headed out toward Break of the Lake and went by Davis's house. And then he went into Break in the Lake, and we believe you're going to see him circling the parking lot. Circling the parking lot, looking for one or both of them. And then he starts heading back in town. And this ain't because I say it. That infotainment center says it. He starts coming back into town. And he's on the phone with Meredith. And then he gets on the phone with Davis. And they agree to meet in Hunters Creek subdivision. Place they're both familiar with, have been there, at the intersection of Avid and Sawgrass. You're going to see pictures. They agree to meet there. We believe the evidence will show that William Bud Ackerman's on the phone with Meredith. Excuse me, that Davis McClendon is on the phone with Meredith, and a call comes in from the defendant, and he says, hold on, to Meredith. And then David McClendon starts talking to Bud Ackerman. That phone's still active as this is happening. Defendant's got her on hold, and he's talking to the victim. And they've agreed to meet at Avid and Sawgrass. And then, ladies and gentlemen, you're going to see that Davis McClendon got there, parked his car with his lights on, and is sitting there, we believe the evidence show, waiting to meet with Bud Ackerman, like they'd planned, at a place they'd been to, knew it, waiting to talk, waiting to fight. I don't know. And the evidence will show the defendant left, brake on the lake, came back, rides around in the air, goes back, backs up into a driveway where there's folks live right near there. And then he starts coming down and goes down Avid and Sawgrass, comes into Hunter Creek. And then you're going to hear from two people in just a little bit. One of them is Terry Cummins, who lives in that neighborhood. Installed a video system in his house. And after this happened, law enforcement went to the neighborhood and says, anybody got any cameras? And Terry Cummins had a camera. And thanks to a bug, motion activated, you'll see the defendant's truck coming down. You'll be able to see it, crashing into Davis's car with Davis right beside it. There's another fellow you're going to meet, Roderick Masita. Lives in the neighborhood. He had a camera on his door, a Ring doorbell camera. He captured on his Ring door camera the defendant's truck coming down, passing down in front of him. Right after that, Mr. Cummings' camera catches the crash. You're going to hear the crash on Roderick Masita's camera. And you're going to also hear, and Mr. Masita will tell you what he thought he heard, you're going to hear that after the crash, listen to this, ladies and gentlemen, respectfully. After the crash, you're going to hear some yelling. You're going to hear what we believe the defendant gets out, goes over to the victim, and you're going to decide what he says. You're going to listen to that, and you're going to decide, and we'll argue in closing what he says. But I want you to listen for the words, and I want to listen to the tone of what the defendant screamed at Davis McClendon as he was dead on the road. Listen to that, and you'll decide if that is malicious, is that an intentional act? And he hit him at 111-34. What happens after that? He gets out, he yells. He leaves. The evidence will show he left. He left. Something happened to his truck. Caused that oil spill. He backs up and leaves an oil spill back to his folks' house, which is just right up the road. You're going to have pictures. A young lady named Megan McGovern, who babysat for the Ackermans, talked to Meredith. She went and picked her up. He said this is where they were supposed to meet. She's getting concerned. She hadn't been able to get in touch with David. She drives down there. Drives down there and parks right beside the vehicle, right beside Davis's vehicle. They don't even realize where he is to start with, but ultimately find his body off to the side. She's going to testify and tell you about what she found. She calls 911, law enforcement comes, and the investigation starts. And once they're told, law enforcement, that, hey, the defendant and the victim were supposed to meet right here, he lives right up the road. Law enforcement went up the road. There was actually an oil stain leak, but they went up the road 41 minutes and 44 minutes, 21 seconds later, and found the defendant in his driveway. Ladies and gentlemen, that's what this case is about. An intentional killing of Davis McClendon by Bud Ackerman. It's that simple, but it's important. God knows it's important to everybody. So all I'd ask you to do is just listen, use your common sense, weigh the credibility and believability of all the witnesses. And after you've heard all the evidence, I'll be up here respectfully asking you to find the defendant, William Bud Ackerman, guilty of murder for intentionally driving his 7,000-pound truck at 25 miles an hour into Davis McClendon and killing him. Thank you.
Good morning.
Good morning.
My name is Jack Swirling, and I am a lawyer practicing in Columbia, South Carolina, and have had the privilege of coming up here to the Greenwood area on a number of occasions over the years that I've been practicing law. And again, it's a privilege to appear before you, a Greenwood County jury, and represent Mr. Ackerman in this case. I am a lawyer who defends individuals who are accused of crimes. And the state is prosecuting this individual, and we both have, as Mr. Metter said, a role in the case. But our role is to seek justice, to make sure that justice is done. And to make sure, my role is to make sure that no one is convicted of a crime unless the state has evidence beyond a reasonable doubt that they committed the crime that's charged. In this case, the state has brought a charge of murder. And of course, Mr. Metters has pretty much defined what his view of what murder is. But I don't have a lot of dispute about that. Mr. Metters has said on a number of occasions that it's an intentional killing with malice aforethought. And that's going to be the issue in this case, whether or not Mr. Ackerman's conduct in this case amounts to intentional, to go ahead and satisfy the state's burden beyond a reasonable doubt. We maintain that Mr. Ackerman did not act intentionally in this case, that he did not kill the individual, Mr. McClendon, with malice aforethought or intentionally. And that's going to be something you're going to have to decide during the course of the trial. You're going to hear evidence that's going to be presented by the state, and we're going to be able to cross-examine the witnesses who offer that evidence. And I just ask you to keep an open mind throughout the course of the trial as to whether or not the state has met its burden of proof. Excuse me, I got a little short of breath there. We spent a good bit all day yesterday really selecting a jury. And why do we do that? Everybody wants, the judge, the state, and the defense, wants a jury that doesn't come into court with any preconceived opinions, has not expressed an opinion about the guilt or innocence of a defendant in a case. We want people who are able to come in, have not formulated that opinion, and have not taken whatever they've heard in the street or in the media or anything else, and already formed a conclusion. So if you remember during yesterday, a number of people would come up and the judge would examine them and find out what they wanted to say. We had an opportunity to ask some questions as well. And at the end of the process, we went ahead and selected the jury. Now, at that point, when we started doing the jury selection, the judge was satisfied that we had a fair and impartial jury out of all the members of the venire that had been brought in. The prosecution was satisfied that everybody who was going to be selected out of that venire was fair and impartial and could render a fair and impartial verdict in the case and had not reached a conclusion. And I was satisfied, me and Mr. Ackerman were satisfied, that the people that were left were going to be fair and impartial and had not formulated an opinion or expressed an opinion about the guilt or innocence of Bud Ackerman. There were a number of jurors who were excused by the court. There were a number of jurors who were excused by the state. There were a number of jurors excused by me. That's our right to do that, all the judge, the state, and the defense, to go ahead and bring together 12. In this case, we have 5 alternates, but in this case, to bring together a jury who has not been influenced by outside discussions or outside media or anybody's opinions, to come into court and had not decided this case before they came into court, did not have an opinion, had not expressed an opinion, and sit in judgment on this case. And we are all satisfied that the members of the jury that we have right now are that jury that we can go ahead and count on being fair and impartial and listen to the evidence in the case and then decide what the appropriate verdict is. Folks, you're the most important people here. I mean, the judge is very important. Obviously, he's going to be deciding issues of law, and he keeps things moving. Mr. Metters, Mr. Conrad are advocates for the state. I'm an advocate for the defense. What we say is not evidence in the case. What we are doing is asking you to look at the evidence, and in some cases, we may suggest what we think the evidence may show. But the fact of the matter is we are advocating a position. And during the course of the trial, Mr. Metters and Mr. Conrad may object to evidence, and I certainly may object to evidence. And then the judge gets to rule on that. But who decides the facts of the case? You do. You are the ones that decide the facts. And the judge will go ahead and instruct you at the end of the case as to what the law is in the case. Now, you've already heard Mr. Metters say it's an intentional act. The murder is an intentional act, and Mr. Ackerman acted intentionally. We dispute that. Mr. Ackerman has pled not guilty to this charge. So what does that mean? We impanel the jury, we present evidence, and then you decide. Now, during the course of the next few days, you will hear evidence in the case. And as Mr. Metters pointed out, which I totally agree with, we've known each other a long time, that the burden is on the state to prove guilt beyond a reasonable doubt. Now, what that means is that at the conclusion of the case, when you go back and deliberate, if you have a reasonable doubt, the law requires you to find in favor of a defendant who's charged with that crime. That's the law. It's the law here, and it's the law throughout our country. If you have a reasonable doubt, if you hesitate to act, if something bothers you that doesn't make sense, that somewhere along the line the state has really not proven that Mr. Ackerman acted intentionally, then you have an obligation under the oath that you just took to find a person charged with the crime not guilty. That's it. That is your obligation. And you're the only ones who get to decide that. You are the ones who go ahead and decide whether or not they've proven the case beyond a reasonable doubt. Now let me talk to you a couple of minutes about a couple of principles of law that I'm going to ask you to consider. One is, in our country, throughout our state, throughout our country, we have what's called a presumption of innocence. You've heard about it on TV, you've talked about it, it's just, you know, everybody just kind of says, well, we have a presumption of innocence. What does it really mean? In the courts of the United States and in South Carolina, the presumption of innocence means this. When you look at Bud Ackerman right now, he's presumed to be innocent. You have to look at him that he is innocent of the charges that the state has brought against him. And guess what? That presumption of innocence follows him all throughout the trial. Throughout the trial, you are to look at him as someone who's presumed to be innocent. The only time that presumption of innocence disappears, the only time that presumption of innocence goes away, is when the ultimate 12 of you who go in to deliberate decide that the state has proven the case beyond a reasonable doubt. Up until that point, until 12 unanimously agree that the state has met its burden of proof beyond a reasonable doubt, then he is presumed to be innocent. That follows him into the jury room. We have a unique system of justice. That presumption of innocence is so powerful It's what makes us unique among the civilized countries of the world, to presume that a defendant is innocent up until a jury decides that the state has met its burden of proof. Now, proof beyond a reasonable doubt, as I said, it means that at the end of the case, if you have a reasonable doubt, if you hesitate to act, if something bothers you, if the state has not proven something that you thought they should have proven, you have to resolve that in favor of the defendant. Now, a crime such as murder requires a criminal intent. And so when the state has to prove that the defendant acted with criminal intent, and the criminal intent, as stated in this case by Mr. Metters, is that Mr. Ackerman intentionally killed Mr. McClendon. We think at the end of the case, or we submit to you that at the end of the case, you will have a substantial doubt as to whether or not Mr. Ackerman killed Mr. McClendon intentionally. Now, so criminal intent is going to be very important, and the judge will describe to you a definition of what criminal intent means. The judge will also tell you what the elements of the crime of murder are. But let me kind of summarize where I believe the evidence is going to be going, or submit where the evidence is going to be going. You're going to be witnesses testifying, and you are to determine what the credibility of those witnesses is. You may hear different versions of what the facts are, and who decides who's telling the truth, who's partially telling the truth, who's wholly telling the truth, who's not telling the truth? You do. Not me, not Mr. Metters, not Mr. Conrad, not even the judge. You decide the credibility of the witnesses. And you decide that based upon whether or not they have an interest, a bias, a motive in the outcome of the case. Whether or not they've been consistent with what they've told people, or have they been inconsistent? Are they consistent with each other? Are they consistent with the evidence in the case? That's how you decide the credibility of the witness. There is no school to go to, there's no book you can read about how to determine the credibility of the witnesses. Can I get a little water?
Yeah, Trudy,
yeah, I just getting dry. Mr. Metters described to you what we had here is a situation where Bud and Meredith Ackerman were married. Excuse me. Thank you. Excuse me. I'm sure they provided water for you in the jury room also too. So Bud and Meredith Ackerman are married. They have 3 children. Mr. Ackerman thought they had a pretty strong union, strong marriage. But at some point, Meredith Ackerman decided that she wanted to go ahead and end the marriage. Now, that does not automatically mean that the person who is not wanting to end the marriage just accepts that. I mean, let's face it, if you've fallen in love and you've lived together for a number of years and you're building a career together and you have 3 young, beautiful children, not everybody's just going to go ahead and agree, okay, you want to end the marriage? I don't want to. Let's try something. Let's do something. Let's not just end the marriage. Bud did not want to end the marriage, but he was working through and trying to accept what happened. Some point, as Mr. Metters pointed out, Meredith started seeing Mr. McClendon. They were still married, okay? Let's make sure everybody understands that. Meredith and Bud were still married at that time, even when she was seeing Mr. McClendon. And by the way, Mr. McClendon knew they were married, okay? Now, at some point, going into May, Mr. Ackerman had a conversation with Mr. McClendon and expressed that he was just unhappy about the fact that his wife, that he was seeing his wife, and they kind of tried to talk about it a little bit and see what they could do, but it really was, the marriage was over, and Bud had to go ahead and eventually accept it. On May 7th, Bud is still reeling from the fact that his wife wants to leave him. They've got 3 children. I said, trying to build a career, build a family. But he's aching. And you can imagine that. You can understand that he's going out with his wife and he does not want to separate from his wife. He doesn't want to divorce his wife. However, people eventually have to accept that, but that doesn't mean that they do it without emotion. That doesn't mean they do it without longing and caring and loving. Bud Ackerman still loved his wife. May 7th, Mr. McClendon is out with Meredith Ackerman, his wife. And they go to some clubs and they were drinking, and Mr. Ackerman had been to a couple of clubs as well. And during the course of the evening, there had been some phone calls going back and forth between Mr. Ackerman and Mrs. Ackerman. At some point during the evening, Mr. McClendon got on the phone with Mr. Ackerman. And basically, as we understand it, and I think will be presented, I want to meet. Let's meet. Let's talk about this thing. You know, I'm getting tired of you calling your wife, type of thing. And, you know, we're out, leave us alone, kind of thing. Little anger there, little anger. So they agree to meet. Now, they didn't agree to meet to go ahead and fight. They didn't agree to meet to go ahead and destroy each other. What they did is they were going to agree to meet and talk. And eventually, they had decided they were going to go to Mr. Ackerman's house where his parents lived on Old Abbeville Highway. At some point, Mr. Ackerman tells Mr. McClendon, well, I don't want to go there. The children are there. They're staying over that night. So let's meet somewhere else. Mr. McClendon agrees, let's meet somewhere else. Now, again, Mr. Ackerman believes that what they're going to do is meet and talk about this, talk through it, which I think any wife, any husband is entitled to talk through it, find out what's going on, express what I feel, express what you feel. So when Mr. Ackerman goes to meet Mr. McClendon, he believes they're going to talk and try and just see whatever can be resolved about this situation. So they agree to meet at the end of Avis Road and at Sawgrass in the subdivision right off of Old Abbeville Highway. Now, Mr. McClendon got there first. He's driving a BMW. At the end of Avis, right after Sawgrass, there's a dead end. I don't know how many feet, it'll come out during the course of the trial, how many feet from that intersection is the dead end. There's a gate there. And apparently, according to what I understand from people in the community, that's a frequent place for people to meet. So Mr. McClendon goes down there with his BMW, turns around, and comes back and parks at the corner of Sawgrass and Avis Road. He's got his headlights on, shining up Avis Road where he knows that Mr. Ackerman is going to be coming down to meet him, to talk, as far as Mr. Ackerman is concerned, to just have a discussion about maybe how Mr. Ackerman feels about the whole thing. You look at him, you decide whether or not this is the person, the type of individual who wants to get into a fist fight or an argument with Mr. McClendon. You decide that. So he's on his way down there to talk with Mr. McClendon. He comes down Avis Road, and right before, I mean, just seconds before, he sees Mr. McClendon standing out in the middle of the road, near his car, in the middle of the road. But he's not just standing there looking to go ahead and get in a conversation with Mr. Ackerman. He's standing there with his shirt off. Now, I think everybody kind of knows what it means when someone is going to meet somebody and they've taken their shirt off, and he's waiting in the middle of the road for Mr. Ackerman to come down there. Not only that, not only does he have his shirt off, but he has a blood alcohol level of 0.11, which means that he's under the influence under the law. He was driving, had been driving under the influence. So there he is, standing in the middle of the road, got his shirt off. You decide why he had his shirt off. He's intoxicated, and Mr. Ackerman is coming to that intersection. At the very last second, you will hear testimony that Mr. Ackerman saw someone standing in the middle of the road. Couple of seconds now. And at that point, you will hear testimony that he veered to the left into the BMW and hit the BMW, which was at the corner of Sawgrass and Avis Road. Why did he do that? He did that to avoid hitting Mr. McClendon, who was standing in the road with his shirt off, ready to fight. Why else would you steer left coming down the road and hit the BMW, which is facing you with its headlights on, except to avoid hitting him? Unfortunately, tragically, for everybody involved, he veered off, hit the car, the BMW, veered off and hit Mr. McClendon, and Mr. McClendon died as a result of his injuries. Now, does that sound like an intentional act on the part of someone? Or are there extenuating circumstances here that you didn't know when Mr. Meadows was giving his opening statement that make it a little bit different? Who is the aggressor here? Mr. McClendon was ready to fight. Mr. Ackerman had no intention of it. And at the very last second, when he saw him standing in the road, he took evasive action to steer away from Mr. McClendon. But as you will hear, unfortunately, he hit Mr. McClendon. Ladies and gentlemen, this is not an intentional act on Mr. Ackerman's part. Did he hit him and cause his death? Yes. But that does not make it murder, because it has to be intentional. He had to intend with malice aforethought to kill Mr. McClendon. Here, he took evasive action, never went there with the intention to fight, took evasive action at the last second when he saw him, ran into the BMW, but veered off and he actually hit Mr. McClendon. Accident. That's what you're going to have to decide on this case, in this case. Was it an intentional act that he ran him over and killed him? Or did he take evasive action and hit him by accident? That ultimately would be the decision in this case. And the judge will charge you on all of those principles of law at the end of the case. But I wanted to kind of give you a preview of what we submit the evidence is going to be, so you'll understand what's happening in this case. And that's a synopsis of it. It's not the complete story. But we're satisfied that at the conclusion of this case, when you go back and deliberate, you will have a doubt as to whether or not the state has met its burden of proof. That whether or not Mr. Ackerman intentionally killed Mr. McClendon. We submit he did not. We submit he did not. We submit it was an accident. And we submit that Mr. McClendon was there ready to fight. It's clear from the evidence in the case. So at the end of the case, we will have an opportunity again to address you after the evidence is presented. The judge will go ahead and charge you on the law. I just ask you to withhold judgment in the case. All this time, you have not expressed an opinion. You have not formed an opinion. You told us all under oath, told the judge, told the state, told me that you have an open mind about it and have not reached a conclusion. I ask you not to reach a conclusion until you go into the jury room. But remember throughout, that presumption of innocence goes all the way with you at the end of the case into the jury room and does not get removed from the defendant until they've proven the case beyond a reasonable doubt. Thank you.